What I'd like to cover today is building upon some of the lessons learned in our referral of cases to national jurisdictions. And many of these, as the prosecutor mentioned yesterday, are being documented in a best practices manual that's still underway and will be released probably by the end of the year. But I thought I'd give you some highlights of what will be in the manual and some of the key findings that we've had. One thing we want to talk about this morning is just a summary of some of the issues and obstacles that we encountered in finding states that were willing and able to take on international criminal cases. And I'd also like to talk a little bit about building partnerships to restore national justice. We've heard about that from some of the other speakers, so I won't dwell on that in great detail. What I'd like to really focus more on is how we went about in our cases of building the case for proving national capacity. And I think our experiences in the different referrals of cases to different jurisdictions varied and provide some useful information. I also want to talk about one of the ways that the tribunal, through its orders of referral, created some effective safeguards for the protection of fair trial rights in national jurisdictions through effective monitoring and revocation procedures. And then I'll just offer a few concluding thoughts that may be of use to other prosecutors or other national jurisdictions interested in receiving or accepting referred cases. So let's start with the first one in terms of finding states that are willing and able. And this framework in terms of willingness and ability or capacity really comes from the rule itself, which is ICTR Rule 11 bis, which we've heard about in prior discussions. And it provides that the ICTR can refer an indictment to any national jurisdiction that's willing and able to prosecute the cases, provided that the ICTR chambers are satisfied, essentially, that the trial in the referral state will be fair and that the death penalty will not be imposed. In many ways, the same concepts of willingness and capacity underlie the principle of complementarity that underlies the Rome Statute and the ICC jurisdiction, which is an assessment, of course, of whether the national jurisdictions are willing and able to take the cases, and if so, then they will have the primary responsibility for prosecuting those cases. Now, as we heard yesterday, of course, the ICTR statute is different from that, because the ICTR statute gives primacy to the ICTR. I think 11 bis, though, is an exception to that. It's the one situation under our rules where the ICTR has a formal mechanism for deferring its primary jurisdiction in favor of national prosecution. What we've encountered over the years in various attempts to refer cases is a very great difficulty in finding states that were willing to take these cases. And here I'll just refer to what the prosecutor said in his opening comments. The problem is that international cases are very complicated. Witnesses are scattered at far-ranging places. Interpretation is often required. They require a great deal and a great investment of costs and resources from a national jurisdiction. And as I think many of us know who have prosecuted in national jurisdictions are already under tremendous strain. There are plenty of cases to prosecute at the national level. As public servants and as public offices, they also have limited budgets. So there's a real financial and resource constraint in terms of the willingness of states to take this on. The other major obstacle we encountered was in the capacity of states. We encountered several legal obstacles in terms of finding a state, even if they were willing to take the case, about their capacity to do the case in a manner that was consistent with the ICTR's referral standards. And one of the critical elements was whether the national jurisdiction or the domestic jurisdiction incorporated the international crimes that were subject to the ICTR indictments into its domestic law. And here I'll pick up on what Justice Byron said, which was the situation in our referral of cases to Norway, the Baragaraza case. In that case, the ICTR attempted to refer one of our genocide cases to Norway. It turned out that Norway did not incorporate the law of genocide into its domestic law. Instead, what it proposed to do was prosecute the case as a homicide case under its domestic law, taking into account, of course, the fact that there were multiple homicides committed in this genocide and assessing that gravity. Now, the ICTR chambers found that that was not a suitable jurisdiction, because that did not reflect the extreme gravity of the crime of genocide. It was just a common law crime or an ordinary crime of homicide. And also it didn't reflect the legal elements required for genocide, including specifically the element of genocidal intent. So that attempt to refer to that domestic jurisdiction was denied. Following that, the prosecutor attempted to transfer the same case, and in this case, the accused actually consented to the referral process, this time to the Netherlands. But there too, we encountered two other problems that are representative of other jurisdictions with difficulties in taking referred cases. One involved the principle of non-retroactivity, which requires that even if the domestic jurisdiction incorporates the same elements of international crime into domestic law, those elements in that crime must have been a crime under the domestic law at the time it was committed. So the incorporation had to occur, had to have been in place at the time the actual crime was committed, or at least at the time the person was being prosecuted. Now, the referral to the case to the Netherlands didn't have that because the crimes were committed in Norway, and the laws incorporating the international, the genocide and other international crimes that were charged in that case were not incorporated in domestic law at that time. It also, another issue there was whether the accused was physically present in the domestic jurisdiction at the time the crimes were committed, or at least at the time the case was being prosecuted. The issue in the Netherlands, of course, was whether he was voluntarily present, because he was actually physically transferred pursuant to an order from the ICTR, and his jurisdiction was handed over was basically compelled transfer from the ICTR to the Netherlands. So the physical presence test also was not satisfied in that case. And that also raises this sort of nexus issue, raises another issue in other jurisdictions that also require that the accused have some physical nexus to the domestic jurisdiction at the time the crime was committed, or at least at the time the case is being prosecuted. And few jurisdictions, few of our cases would meet that requirement. The other major obstacle, particularly in looking for suitable jurisdictions in Africa, was the applicability of the death penalty, which remains on the books of many jurisdictions and is an automatic bar to any referral. Now, over the years, two states have proved both willing and able to take cases. We will talk mostly about the Rwanda cases, but there were two cases also accepted by France, and Rwanda also currently has 8 cases that have been referred to Rwanda. I think the approaches in both of those referrals differ, and we'll try to highlight some of those differences as we talk about some of the lessons learned. But I think the lessons are going to be useful not only to other courts that are seeking, or national jurisdictions that are seeking to refer cases to other national jurisdictions, but also to those national jurisdictions interested in accepting the cases and establishing their own capacity to prosecute international criminal cases fairly. Now, with regard to the referrals in France, these two fugitives were arrested in France. They were on French soil at the time of their arrest. France willingly accepted the case. The ICTR, in reviewing those applications, looked at France's legal framework, which has a well-established and documented record of prosecuting cases fairly in compliance with international standards, and also didn't have the applicability of the death penalty was not an issue there. So those cases proceeded rather quickly. In less than a couple months, 4 months or so, the referral process was completed and the cases were formally transferred to France. And since then, monitoring has been implemented by the prosecutor to ensure an effective prosecution in France. And most recently, with the establishment of the mechanism for international criminal tribunals, the tribunal is also implementing a monitoring mechanism for those cases, which, as I say, was referred in 2007 and are still in the investigative stage, getting ready for trial proceedings. Now, the situation in Rwanda was a bit more complicated. As Judge Byron noted, the prosecutor's first applications for referral were not successful. 5 applications were filed in 2007. They were vigorously opposed, unlike the prior referrals to Norway, the Netherlands, and France, where there was not much adverse litigation. in these applications, they were vigorously opposed by not only the accused, but a host of human rights organizations. The strategy at the time was, again, to look at the legal framework existing in Rwanda at the time, which is the same we used in the referral of cases to France. The difficulty, though, was that Rwanda's legal framework post-genocide was not as established at that time. And as Judge Byron said, the chambers rejected all of those because they found defects in a whole host of things, including application of the death penalty, solitary confinement, the free conduct of defense investigations, the availability of witnesses, the availability of witness protection services, and judicial independence. Now, those decisions, though, really laid the groundwork for creating a pathway to what needed to be done to help restore capacity in Rwanda. And I won't dwell on this because I think it's already been covered. Mr. Amasuga spoke about this in part yesterday, and some of the other speakers also, about the ICTR's work to develop partnerships aimed at improving the capacity of Rwanda to take referred cases. And those reforms, or those partnerships, which were with a variety of member states, international organizations, regional organizations, Interpol, and other groups, resulted in significant changes on the legislative front, infrastructure improvements in terms of, as Judge Byron said, the creation of new prisons, state-of-the-art prisons, knowledge sharing, as Mr. Amasuga said, a lot of outreach and training by all branches of the ICTR to the Rwandan counterparts, and as also experience transfer. I think, as the prosecutor mentioned the other day, the fact that we work side by side with many Rwandans, at least in the most recent years of the tribunal, those people have now moved back to Rwanda and are in positions of influence in Rwanda and have been enriched by their experiences at the ICTR by being exposed to fair trial rights and international standards. Some of the key lessons learned, though, is that capacity building does not come cheaply. And as Registrar Majola mentioned yesterday, there is no money in the ICTR budget to do these kinds of things. We had to rely on outside partnerships to find them. So one lesson learned is that we need to make sure there's an adequate monetary framework for providing meaningful support to allow this kind of capacity building. And capacity building, and I think Dr. Clark mentioned this the other day, is that you can't just do this as like a top-down thing. The international prosecutors will come in, or the international actors will come in and tell the national actors what they're doing wrong and how they can fix it. That would never work. The only way we were able to get the information from Rwanda was to do an assessment based on hands-on interviews and discussions with our counterparts in Rwanda, where we were open to listening to how they approach things, learning from their approach, and trying to see how their approach fit in or didn't fit in with international standards, and then working together to find a solution that would improve the national system or bring it up to the same standards, or actually that was just reflected as it was, maybe a different approach to the same end. But that kind of information gathering and needs assessment really has to be conducted in the framework of having some sort of existing relationship, because you can't have that kind of dialogue with national actors unless there's some ability to trust each other and to understand the purpose of getting the information. And that takes a lot of time on the ground, and it takes a lot of building partnerships and relationships with the national counterparts. And it's only in that way of mutual understanding that you can come up and identify the areas where capacity could be improved and how you, as international actors, can help bring together the other actors to help work together to improve or to restore national capacity. And one way, I think, from our experience is the other thing that matters is not talking in abstract terms, but really focusing on practical, hands-on experience. This was done through all of our trainings in terms of sharing knowledge, for instance, in the prosecution of cases by our most experienced prosecutors, conducting mock trials, doing real detailed assessments based on what we learned in our indictment drafting. Again, as Judge Byron referred to some of this, we shared some of those tips with our Rwandan counterparts and looked for ways to mesh our understandings of things with the Rwandan national practice so that we came up with something that reflected both. And as a result, that also reflected and proved that the fair trial rights would be protected if the cases were referred to Rwanda. The one thing that I think we did in later years that perhaps we could have started earlier if security situations permitted would have more embedded teams to work really side by side with Rwandans. We've sort of done this by ad hoc approach because it's sort of just been the natural progression of the fact that we've worked with many of our Rwandan counterparts in all phases of our cases, and some of them have now returned to Rwanda. But we could have a more formal system would be a good idea of doing that in the future, because it's not just a training program, it really is working hand in hand as partners in cases and as colleagues on cases and addressing things as they come up. Again, if any of these things really require sufficient funding. A lot of this has been very much dependent on outreach efforts and donor support, which is a very time-consuming process, and is something that if there's a real commitment to doing complementarity and having national actors take primacy in the prosecution of international cases, it requires a system for enabling that to happen. And lastly, one other lesson learned in the Rwanda situation is that one of the fallbacks of doing all these improvements on the Rwanda side was that Rwanda was then criticized for having a two-tier justice system. That many of these reforms were created and applicable under the transfer law that was adopted only to referred or transferred cases, and that domestic cases were not benefiting by that. But I think the answer to that criticism, which came up in several of our referrals, is quite simply that Rwanda is actually now using these same reforms and extending them to domestic cases as well. You see that in the extension of witness protection services to domestic cases, the construction of a new state-of-the-art facility that will not be just for referred or transferred cases, but for domestic cases as well. Wholesale reforms of the penal code and code of criminal procedure that on the penal code side reduce penalties across the board for violations of domestic law. And on the code of criminal procedure, streamline procedures for admission of evidence, including more clarity on the use of accomplice testimony in criminal cases. All of those reforms are now being implemented on the domestic side as well. So here too, the critics of the referrals were trying to create a new issue, but that it's a new issue in you're looking at it in the context of an evolving situation. There are still many reforms undergoing in Rwanda that have nothing now to do with the referral of cases, that are really just all driven by the domestic commitment to improve the legal system in a manner that's consistent with fair trial rights. And I think I'll have to wrap up there, but all of that, I think, is consistent with the way we went about establishing the capacity of Rwanda to prosecute these cases fairly, which was to address head-on the criticisms that were directed at the Rwandan legal system and shore them up with not just a reference to constitutional provisions or statutory provisions, the black letter law, but to find for each one empirical evidence and objective evidence that supported, that showed that those rights were actually in practice. And that required on-the-ground interviews, affidavits from all kinds of officials, documentary evidence, third-party evidence in terms of independent studies, press reports and media reports, and everything to shore up that, to show that in fact the rights that were on the books were actually in practice in the courtrooms of Rwanda. And as a result of that, the second round of referral were all successful, and following that, we've already heard about the impact of those referrals on domestic jurisdictions, including specifically on the extradition of cases from national jurisdictions to Rwanda, which has resulted now in several trials ongoing in Rwanda that have been referred or transferred from national jurisdictions. So I'll end there, and thank you.
Thanks.